for coming to another City on the Move presentation. Today we have a great presentation by Mr. Stan Miller with the Wilson Miller Law Firm, who's going to be talking to us about protecting your assets. Inside your folder, there was a little sheet that also gave you some good ideas about questions. So please make sure you ask those questions as they come to you. And once again, thank you for coming out for us.
Rachel, thank you.
All right.
Great to be here. It's especially great to be here on an August day when it was 73 degrees this morning coming in. Wasn't that terrific? I really am happy to be here. I appreciate the invitation. So I'm here today speaking on total protection, and I've subtitled my presentation, "The 5 Biggest Mistakes and How to Avoid Them." A couple days from now, on Thursday, another lawyer in our firm, Todd Watley, who is a specialist in elder law planning, is going to be here also presenting specifically on Medicaid planning. I'm going to touch on that some today. You're going to learn a little bit about that, but Todd's going to give you the whole truckload on Thursday, so you may want to plan to come back for that. I don't know how this works on people watching on TV, but I can tell you that those of you who got up and who are as a part of the live audience are completely free to raise your hand and ask questions, and you won't bother me at all. I would actually rather have you get your questions answered right on the spot while you're thinking about them. If you're like me, you might forget the question if you waited till the end, right? So I want you to feel at home here, feel like it's a safe place to ask any question. What I have found is that a lot of times when people ask questions, there are about 3 or 4 other people in the room that wanted to ask that question, but they didn't have they were too shy to do that. So if you're thinking about doing it, just pop your head up. Okay, got some more people coming in here. So if we keep waiting around long, we're going to have a crowd. This is good. So I want to ask you to consider what I call the 5 big questions. There are 5 big questions that really relate to your planning that I would like for you to ask. And these questions are not all going to apply to everybody, because I know that I'd understood that the audience that we had today was going to really run the gamut from younger to older. And so some of these questions only relate to people that are younger. Some are questions that are more relevant to people that are older, but I want you to engage on all of these. And the first question I want you to consider is, what would happen to my children if I didn't come home tonight? And if that question is not relevant for you specifically, consider whether or not you have adult children who have children, and whether or not that question is relevant for them. The second question is, will my family have to go through the probate process, go through probate court, if I become incapacitated or when I die? A third big question, and this third one's really interesting. This is a question that I find nobody asks aloud. I found out about this question when I did my own estate plan, and it turned out this was my wife's big issue. She said, is my spouse protected if he or she remarries after I'm gone? Big question. I find that question is actually a really big question for people that are regular church attenders, because and particularly wives, because they know how many widows there are at church with casseroles in the freezer. My fourth question is another big one. Are my heirs protected from divorce, from bankruptcy, from judgment creditors, and from their own financial immaturity whenever I leave them their inheritance? My last question is this one, and a big one for sure. Will I go broke in a nursing home, having to pay for long-term care? There's a lot of data out there that says that most people have not actually grabbed hold of and answered these questions. About 70% of all Americans have made no plan whatsoever to answer any of these questions. And I think the reason for that is partly because they don't know what to do, and partly because of procrastination. The idea that We can kick that can down the road. We won't have to deal with it. I had somebody tell me one time, my affairs are such a mess, God wouldn't dare take me and leave a mess like this. But the result is, when you don't plan, that the cost is significantly more. There are time delays that are unnecessary, and I think worst of all, there's family disharmony. All of this results in what, in our office, we refer to as a train wreck. Not having your plan in place really does result in a train wreck. There's some websites out there that talk about famous people that didn't do their plans and what the consequences are. You know, Prince died without any kind of estate plan, and oh my gosh, people have been showing up all over claiming to be his son. One's in prison somewhere. Whitney Houston, Abraham Lincoln didn't plan his estate, and his family would have been in very deep trouble if Congress had not stepped in and provided funds for them for a couple of years until they got it all worked out. But you're not going to be any of those people, I know, because you're going to learn enough today. You're going to learn enough today that by the end of this presentation, you're going to have clear answers about how to answer these 5 big questions. So let me just tell you generally, the individuals that we work with, the families that we work with, are asking us to accomplish 3 things for them. First thing they want from us is a practical roadmap. Like, they sit down with me and they'll say, Stan, tell me how to do this. Do I need a will? Do I need a trust, a power of attorney? What is it I need to do in order to be able to make sure my family's protected? Give me practical answers and give it to me in layman's language so I don't have to learn to talk lawyer talk. That's fair, right? But I also hear something that goes a little bit deeper than that. And that is, I hear people saying to me, kind of in their own way, in doing this, I just want to know that I've done the best job I possibly can to be a good parent or to be a good grandparent. And I also have people give voice to me from time to time this idea. The idea is that by making sure I've protected my family, making sure I've eliminated or at least dramatically reduced the risks of family conflict, making sure I've protected my family, I believe that I've done the very best thing I can do to make my community better and to make the world better. I think most of us look at, how do we make the world a better place? Part of the way we make the world a better place is through the work that we do. Here, you come to work every day, we do, you do stuff. I had a conversation a few days ago with one of your police officials. I'm not going to name names or give titles, but this person was saying to me, I don't always feel appreciated for what I do. I feel like, people yell at us, and when we pull people over for DWIs, they don't appreciate that we're maybe saving their life. All of us, I believe, are built with the DNA material that makes us want to get up in the morning and do good things and make the community better. And I believe that for a lot of us, a big part of how we do that is by building better and stronger families. We do it in a lot of ways, but if we build good, strong families, that's a pretty good win. Let me just briefly introduce you to our team. You've met me. I'm Stan Miller. Todd Watley is going to be here on Thursday. Todd's a specialist in elder law planning. In fact, he went off to law school and graduated, and then he couldn't get enough of it. He went back to law school and got a master's degree in elder law planning. We also have a lawyer with us named George Plasteris, that some of you may know. Anybody here know George? George is going on 86 years old now, and he's at the office, 3-4 days a week? Yeah, pretty spry. Saw his car in the parking lot this morning. Kevin Brunson is a young associate of ours. Kevin's kind of my go-to guy, my assistant on the work that I do. We also have a really terrific team. We could not do the work that we do if we didn't have a really, really terrific team supporting us. I think most of you met Bill Matthews, who's sitting in the back. They're good-looking Bill back there in the back row, who's our Central Arkansas Outreach Director. And maybe all or most of you met Amanda Hunt, who's sitting up here. Amanda is one of the two women in my life who run my life. It took more than one. And so she hands me off to my wife at night, but she has the counter. She knows way more about what I'm doing than I do, actually. So we have others. I'm not going to go through all of these in the interest of time. We have a whole team here that I'm really proud of. They've been, carefully curated by our HR department. So we've got a really solid bench here. A little bit about me. I feel like if you're going to spend a good part of your morning listening to me, you need to know a little bit about me. And so I'm going to tell you a few things. I'm a graduate of Arkansas Tech. I'm always curious. Any tech grads here? Any tech? No tech grads. Wow. Okay. And when I went to Tech, there were 2,300 students, and it's tipping around 12,000 now. So I left and they grew. I don't know if there was a correlation between that. I went off to Vanderbilt Law School, and then I came back to Arkansas and began my practice focused on all sorts of stuff for a number of years until I discovered estate planning and decided I wanted to just jettison all that other stuff that I could have done. I quit doing divorces and I quit going to court, all the stuff that you think lawyers really do, and decided estate planning was really a calling for me. And it really is. I remember the day it happened. I sat down with this lady and she had a story, and I said, "Tell me about you." And she spent 2 hours. I didn't have to say a single word. She spent 2 hours telling me about her, and it was great. And so I figured out what the solution was, and we solved it, and she gave me a hug. I loved it. So our law firm, Wilson Miller, is headquartered over on the 14th floor of the Regions building, right up there. But a couple other things I want to tell you about me that I think kind of round out my resume. About 20 years ago, I was very instrumental in co-founding a company called Wealth Counsel. And about 10 years ago, we extended that into another company called Elder Counsel. What those companies do is they provide a technology software system for law firms that are in the estate and business planning areas and in the estate in the elder law planning areas. And then we wrap around that an education program. And that's relevant to my story because I'm still very involved in the company. I do a lot of traveling for the company. Amanda, who makes my travel arrangements, will tell you that she spends about a third of her time like buying plane tickets and then changing the plans whenever I change the plans. But I'm around the country a lot, and as a result of that, I think I do a better job than most people in keeping up with the changes that are happening and learning what the trends are, and picking up ideas that are being talked about. And I think a lot of that value, I like to believe I bring that home and infuse that into the client relationships that I have. Something else I've done that I'm really proud of, more recently, just in the last couple months, I actually wrote a book and published it. And we've got a couple up here. These are going to be prizes at the end. So stay till the end, and you have a chance to win one of my books. It's called Your American Legacy. The subtitle is Powerful Strategies That Instill Lasting Values for Generations. I'm convinced that this whole conversation about protecting assets is not complete if we don't also talk about how to protect the values that matter and have strategies for how to instill those values in the next generations so that whenever we have to pass the baton onto them, they're fully grown up and responsible and empowered and able to accept the responsibilities of adulthood so that they can run the world while we retire and exit. So this book is about that. I've done my best to make this book really interesting. You can take a look and see if you agree with that. My wife is very helpful in this too. There's a website that goes with the book, and every chapter has resource links, and my wife did all those. So we actually had a debate about did we make her the co-author of the book or not, and I was struggling with, how do you write a sentence, and tell a story? And is it me telling a story? Is it her telling a story? Is it us telling a story? And finally she said, okay, she said, you just put your name on it, but make sure you say something really nice about me in the front of the book. And I did. So if you're too shy to raise your hand and ask questions, or if you think of a question later, make a note of Amanda's email address right there, ahunt@wilsonmillerlaw.com. I get about 500 emails a day, but Amanda sorts through those, and so if you send it to her, it'll pop up, and she'll come in and grab me, and we'll respond to that and answer your questions. So I told you I would talk about 5 mistakes, and let me tell you also, I have a friend who's a financial advisor here in town, and one day I went to his office and I said, we were talking about a case, and I laid the file out and I said, I have a problem here. And he stopped me in the middle of the sentence and he said, I don't want to hear about it. He said, if you're going to tell me you have a problem, I want you to be prepared to have at least 2 solutions. So I'm going to talk about 5 big problems, 5 big mistakes, but I'm not going to leave you hanging. I'm going to tell you what I believe the best solutions are to address those mistakes. So the first big mistake that people make is they don't have a plan for minor children. I don't know, I'm not going to ask for a show of hands of who has minor children here, but this also would apply if you have minor grandchildren. And so tonight you need to go home and talk to your children about this. So if you have no plan for minor children, we don't know who the parents are going to be if something happens to you. We also don't know how they're going to be supported. And so I think the solutions for this are really straightforward and easy. Number one, you need to appoint a guardian, and you do that in either a will or a living trust. And you don't want to name just one. People don't always die in the order they're supposed to, and we have to think about that. And I like to name at least a sequence of maybe 2 or 3 in the backup. This is a really, I think, this is one of the harder things we do, right? It's like, if I'm not here, who's going to be the parent of my kid? Who would do it as well as I'm doing it? Who would do it like I really wanted it done? And so I think that's an issue that you really have to deal with and get clarity around, because what you don't want is to have a court deciding without any guidance from you who's going to be the parent of your child. You need to be able to put that in writing so that you're really clear about that. Secondly, you need to leave some money for those kids, because if something happens to you and there's no money, that means that they're going to be a burden on other family members. And I will just say that if you're young enough to have minor children, and if you're reasonably healthy, there is no excuse whatsoever for not having at least a term life insurance policy that will provide a death benefit large enough to make sure those kids can get all the way through college without having to beg relatives for money. Term life insurance is really cheap now. The life insurance industry has recognized that we're all living longer, and so they keep lowering the rates on it. And so for not very much money at all, you can buy term insurance, and you can buy that with the idea that whenever my youngest child gets to be, grown, whatever age that is that you define, you can say, I'll cancel it. I'll stop paying the premiums then. And I hope that I wasted that money because I would like to still be here. But for a very small amount of money, you can make certain that your kids are going to always have a place to live. They're going to have food on the table, and they're going to be able to get educated. You can do that, and I promise you, you will not miss the money. I think it's also important to make sure that your spouse is taken care of, because let's just say you're the breadwinner in the family. If something happens to you, the last thing you want is to have your spouse have to go out and find a sudden husband or sudden wife in order to be able to have a place to live. It's a whole lot better if they have financial independence, and I really believe that cheap term life insurance is a solution. Whenever I sit down with a young family and there's a breadwinner in the room, whether it's the husband or the wife, I basically lock the door and make them promise me that they will go get insurance in place. There's just no good reason not to do that. The third thing I think is really important is to sit down and write a letter to these new parents. This can be put in a folder. It doesn't have to come out until something really happens to you. If you have minor children, my hunch is that you occasionally go out to dinner. You may take a weekend off. You may hire, anybody ever hired a babysitter to come in and take care of your kids? You remember when you had kids, you ever hired a babysitter, right? So our experience is that most people spend more time writing out the babysitter instructions and putting them on the refrigerator when you're going out to dinner and you're going to be back by 9:30 or 10 at night than they do in planning for their permanent exit. And so I'm just suggesting that part of being a responsible parent is leaving a real clear set of instructions that lay out what vision you have for your children, what you want to happen to them, how you perhaps want to encourage a work ethic in them. If faith is important to you, you'd want to put some things in there about that. But whatever it is for you that's important, you want to give guidance to these new parents of yours, of your children's, so that as after you're gone and as they're now playing the parent role with those children, they can take out that letter from time to time and read it to them. This is your voice after you're gone about what matters. So it's babysitter instructions for when you're not coming back. Okay. Second mistake is not avoiding probate court. So I want to say a few things about probate. I'm going to talk about some of the reasons you might want to avoid probate court, but the first thing I want to say is that contrary to what many people believe, will-based plans do not avoid probate. I was giving talks about this 25 years ago to workshop groups, and I really thought that by 2019 I wouldn't have to be talking about this in front of people, but it turns out that everywhere I go, people will say, I went to see the lawyer to have my will made, and the reason I did that is I didn't want to have my family go through probate. So a will plan does not do that. A will plan actually, in most cases, guarantees probate. And what that means is that there's no privacy. After we're done today, if you can get off for an hour over lunch, you can go over to the probate clerk's office and pull all the files and read the wills of people that died. You can read their asset summaries. You can figure out who's getting their stuff, who they owe money to, all of that. It's all right there for everybody to look at. It's also expensive. There's a statutory fee schedule that sets what the fees are, and I'll show you what that is in a second. It's fairly expensive. It also ties things up for a long time. Our experience is that it generally takes 8 or 9 months at least, and sometimes a lot longer than that. But the other thing that is a common misunderstanding is that wills actually don't control all your property. In fact, most of us have a lot of property that wills don't control. So I'm curious, anybody here have an idea of an example of some kind of property that a will would not control? Yes? I'm going to say asset. IRAs, perfect. Okay, excellent. So I do not pay people to sit in the back and answer these questions so effectively. Right. But anything that has a beneficiary designation, like a 401k plan, 403b plan, IRA account, life insurance. If you die, the life insurance company doesn't really care very much about what your will says. They want to know whose name is in that beneficiary designation. You can also do this with bank accounts. You can go down to the bank and do a pay on death card that designates who it is that receives that bank account when you die. And the bank cares about that when you die. They don't care what the will says. They care what that pay on death card says. So I mention this because a lot of people think that when they go have their will done, it's somehow like a magic wand that they wave over everything, and now everything is going to pass under the terms of the will, and that's not the case. So I mentioned that probate's expensive. I just want to briefly show you on the screen how probate fees are calculated. You'll see there on the left-hand side the dollar amount of your gross estate. So, you know, if you have a $100,000 gross estate, what do you pay the personal representative, or what we sometimes call the executor? What do we pay the attorney? And then what's the total fee? If your estate's $250, you see a different number there. $500, a different number there. But the point I want to make about that is that that gross estate number is based on gross value, not net value, which means that you don't get to deduct out of that the mortgage on your house. Okay, so if you have a $100,000 gross estate and a $90,000 mortgage, you might think, I have a $10,000 estate, right? But for probate fee purposes, that's not how we look at it. Okay, so again, all of this I believe should be avoided. Quick question, anybody recognize this guy? I have to confess, I never saw the show. But we know a lot about what happened when he died. We know about who got all of his stuff. You know, we know that he left, we know that he left $7 million in a life insurance policy that was mentioned in his will to his son. It appears that he also gave two nieces $500,000 each. He had a godson who got $100,000, $200,000 went to a close friend. He paid his assistant $200,000. You know, all of that we know. How do we know that? Why do we know that? Pardon? So yeah, when his will got filed down at the probate clerk's office, they listed all of his assets. The will was filed, and you got to see who got everything, right? So I have a friend, a good friend of mine, who has defined probate this way. He says probate is a lawsuit you file against yourself with your money for the benefit of your creditors and for the benefit of your disgruntled heirs. What probate does is it creates a ready-made venue for people who want to argue about stuff to easily come to court. It's like you paved the way, you rolled out the red carpet, and you sent them a notice and said, if you want to argue about this, here's how you do it, come on down. Probate should be avoided, and we're going to talk about how to do that in a minute. Pay on death cards, yeah. Mm-hmm. Yeah, so if you go into the bank and say, I want to do a POD, pay on death, they'll get out a card, and you can designate on that card who you want to receive that bank account balance when you die. And that doesn't pass under will. It also does not go through the probate process. Okay? Question back? Yes, ma'am. I told you guys, I don't pay people to ask great questions like that, but yes, there is, and I'm going to get to that. I told you I wouldn't give you a problem unless I gave you a solution. I want to get you a solution in a second. But I'm not quite to the solution yet, because I want to talk about something else that I think is a really big deal and a big mistake that people make. Because so many people believe that if you put property in joint names with other people, that avoids probate. Now, the truth is that sometimes it does, and I'm going to talk about how that works, but I also want to point out the danger of joint tenancy property. I think joint tenancy is really dangerous, but people don't recognize the danger of it. So let me give you a little example of what I'm talking about. So let's suppose I've got a lady, and she has 3 children. She's got a daughter, she's got 2 sons, and the middle son, the middle son is divorced and he owes child support to his ex-wife. So the first problem I have is so what she did is that she took, and I use the example here of a CD, which is like the simplest example I could come up with. So she just put everybody's name on the CD. What I'm saying to you would be just as true if it was the house, or a piece of real estate or a brokerage account, anything that you would put other people's names on jointly. So she put this property, this CD, in her name and the names of her 3 children. So all 4 of them owned it. If this son of hers doesn't pay his child support, which has been known to happen, his ex-wife can go to court and get a judgment and come levy on this CD. Now, this is all mom's money, and the only reason she did this was to just make it simple. So that's an example of a hidden danger in joint tenancy property. But there's some others. I'm not going to go through all of them, but I mentioned earlier that sometimes people don't always die in the order they're supposed to. So in this instance, this son with the 2 children died, leaving his 2 children. And then sometime after that, mom died. So I have a test question for you. Who owns the CD now? I want to see a show of hands of the people that think they know who owns the CD. All right, so who do you think owns it?
I think the 2 children that she left and those grandbabies.
Okay, so you think it's the 2 children and the grandbabies. What, you think that too? You say what? You think the grandbabies own the whole thing? All right. I've never gotten that answer. You think the grandbabies own the whole thing? Really? Okay.
No, not the grandbabies, the siblings.
So
Children,
the 2 children.
children that are left.
Okay. Who do you think?
The 2 children and the son that died, his
Okay.
children. Yeah.
So I love this question because I always get, like every time I have this conversation, it ends up about a 50-50, of the people that are brave enough to, weigh in on the answer. But this is called joint tenancy with right of survivorship. What that means is that if your name's on the title and you are living, you own it. So what happened here is that the grandbabies got cut out. Yeah.
Wait, you said it's joint tenancy
With right of survivorship.
rights of survivorship.
If your name is on it, and there are 4 names on it, mom and the 3 children, so whenever the middle son died, it was owned by mom and the 2 children. When mom died, it's owned by the 2 children.
But what about the right of survivorship? Doesn't that
That,
include the children?
it means ownership passes to the survivor whose name is on the title. It's always worded that way. That's if you just say joint tenants or joint tenants with right of survivorship, that's how it is. Okay. So what happened here is the grandmother, without intending to do it, I'm sure, cut out her 2 grandbabies, right? And so what I get sometimes is I'll have parents will say, I'm sure my kids would do the right thing. But it's remarkable to me how in my own practice experience, I've had those 2 surviving children sitting in my office, and you know what they said? Mom is really smart. She knew exactly what she was doing. And by the way, our brother is a jerk, and we don't want to, and so we don't have anything to do with his kids. So I don't think the result that you see here is the result that most grandmothers would want. Okay, and so this is the unintended consequence of joint tenancy. And I spend a little bit of time talking about this because joint tenancy, I think, may be the most popular estate planning tool that people actually use. People figure, I'm just going to put other people's names on stuff. And so I just want to point out that it's it has serious adverse consequences. It actually works. Joint tenancy works if everybody dies in the right order. Okay, and if nobody gets sued and gets a judgment against them. Okay, and it also only works if the senior generation person who puts other people's names on it are willing to give up control. most of us, if I asked for a show of hands, I'm not, but if I did, if I asked for a show of hands of how many of you are willing to give up control of your property to your children, there wouldn't be very many hands go up in this room, I don't think. I see, you would do that? Okay. So let me tell you a story about that. I had a client a number of years ago. The family was basically a father who was quite elderly and one son. The father was fairly well off, and he went into a nursing home. And when he went into the nursing home, he said, I just want to make things simple when I'm gone. So I'm just going to put my son's name on everything so that whenever I die, it'll just be his. And he did that. And then a few months into his experience of being in the nursing home, something very magical happened. He fell in love. It was really cute. There were actually newspaper stories about this. He marries this other woman who is in the nursing home. They had a big wedding ceremony. They put them in their wheelchairs and tied cans to the wheelchairs and rolled them down the hall. They really did this. The son finds out about it, and he comes out to the nursing home and he says to his dad in anger, and in fact rage, he said, I am so disappointed. I cannot believe that you dishonored my mother's memory by getting married again. And he said, I just want you to know that I'm not signing any other legal document you want me to sign. So effectively what happened is all of this jointly owned property is now frozen, and the dad has no ability to access it because he has to get the son's agreement to sign stuff. So I just want to point out that when you put other people's names on things, not only do you make it subject to their creditor claims, not only do you risk having it pass in ways you wouldn't want it to pass because people didn't die in the right order, but you also give up control over it. And that's something most of us, are not willing to do. I believe the best way to avoid probate, and this is in answer to your question, the best way to avoid probate and all of the consequences of joint tenancy property is with a revocable living trust. Revocable living trust became popular, a popular estate planning tool back in the mid-'80s. Up until the mid-'80s, the way most people did their estate plans was they would go see the lawyer and have a will done. But in the mid-'80s, there was a real shift that took place away from that, because what people realized is that you could go see the lawyer and have a will done, and you didn't pay very much for it. But then when you died, you had to, the family had to pay this hugely expensive probate fee, and things got tangled up in court and took forever. A revocable living trust was designed to avoid all that. So a revocable living trust, really, if you think of it as a will substitute, that would be a very valid way of thinking about it. So in this little chart that you see on the screen, you'll see on the left-hand side, I've got a little box that has my property in it. And you'll see that in order for my property, when I die, to pass to my heirs, it has to go through the probate process if it has just my name on it. But if I take that same property and retitle it over into the name of my revocable living trust, then whenever I die, the property passes under the terms of the trust, and it doesn't have to go through the probate process. It's just as simple as that. I take my property, retitle it over into the name of my living trust, and then when I die, that property passes immediately to the heirs. I mean, there's still stuff to do. You have to retitle it. It doesn't retitle itself, but you take out almost all of the work that would otherwise be connected to a probate proceeding. So I want to give you a way of thinking about how living trust planning works. I'm going to redo this slide one of these days. I don't know if you all think that's a very clear picture or not, but what I'm intending to show is that that's a chest of drawers. I really think the best way to think about a living trust is just to imagine that we're building a chest of drawers. Everybody has one of these, right? You've got one that it has a top drawer, it maybe has a middle drawer, maybe a couple of middle drawers, it has some bottom drawers. So when I create a revocable living trust, what I'm really doing is I'm building a legal chest of drawers. And then I open the top drawer. I put all of my stuff in there. And then when I die, somebody opens that top drawer, takes it all out, and puts it in the middle drawer. And then whenever my spouse dies, we open the middle drawer and take it all out and put it in the bottom drawers. If I have 2 children, we divide it between those 2 drawers. So we're just moving it from the top drawer on down, but we build the entire chest of drawers whenever we create the trust. All that's built, and it's revocable. You can change your mind about it, up until the time you die or become incapacitated. But when your assets and your property pass through that living trust arrangement, it keeps all of that out of the probate court. So let me stop there and see if we have questions about this. You've all heard about living trusts. They've been around a long time. Probably some of you have one, but there are always questions about that, and I want to make sure you don't leave without having those questions answered. And yes, ma'am.
I want that.
A lot of people get ahead of me, so I mean, that's,
Your greatest fear is that your demented self will make irrational decisions and not leave your money where your rational self wanted it to go. Been there, done that, with finance, and honestly know that the courts are extremely reluctant to declare guardianship. And, my fear is that I will make irrational decisions. And you talk about the son being mad because they're married.
right.
The last thing on this earth that I really want to happen is I don't want my money to go to my husband's second wife children.
Right. So I've got an answer for that. I want to get to that. But the demented part, let's talk about that, okay? So when we create a revocable living trust at a time when you're clearly not demented, okay, and you're sitting there looking at us across the table, we're pretty good at determining if you are or are not demented. So at a time when you're clearly competent, you would create a living trust. And one of the provisions that we put in that trust is a provision that says that if 2 doctors sign a piece of paper, and we actually print out the sheet of paper and put it in your, I've got binders of trusts up here if you want to take a look at one. I put it in a tab there so that it's readily available, so that if your family members think that you're moving toward being demented, and they can convince 2 doctors that you are demented, and that such that they sign that sheet of paper, that takes away your power to change everything. Okay? Now, if you disagree and think that you are not demented, then you always have the right to go to court and get a court to say you're not. But we make it, I want to say, relatively easy to take away your power to make those changes. Because in our experience, what we found is that it's been rare for children to actually abuse that power. Usually we find they actually wait longer than they should to exercise that power. Okay? Yep.
The other problem is that my mother went in and simply unfunded the trust account with money. She pulled all of it out and moved it to a private account. That's another issue.
So for a living trust to work properly, it actually has to own your stuff, right? And if you go in while you're living and take everything out of the trust and put it back in your name, then the trust doesn't really work. So I don't know what motivated her to do that. I don't know if she was not competent when she did that, but I can't explain that. But that really does undermine the plan. Yes, ma'am. That's correct, but this is not an irrevocable trust. This is a revocable trust. So trusts are like ice cream. They come in a lot of flavors, okay? So when you hear the word trust, it doesn't, there are many different kinds of trust. The specific kind of trust we're talking about here is a revocable trust. It's merely a will substitute. And because it's revocable, any day that I tell clients, when you get up in the morning, take your pulse, and if you have one, you can change this. Now, there are reasons why we would do irrevocable trust, and I'm going to talk about that in a minute, but most of the basic estate planning we do for clients is using revocable trust because they don't want to give up the right to change their mind about who gets stuff when they're gone. Okay? Yeah, there's some good reasons to give up the right to make changes, but mostly, at least in a revocable trust context, you want to keep the right to change your mind. Okay? That's
Is the owner or the one that has the property in that revocable trust, is that the only person that can change anything?
yes. Yes. Or if it's a joint trust and a husband and wife do it together, they have to agree on making changes. Okay? Yes, ma'am.
My question is very long, but can it pick up my voice?
I don't know. What's the deal on the audio? Well, you know, we're hanging on your every word here, so.
Are there any provisions to a father who has a living trust for his proceeds to go to his children after he dies, and then there is an older child that comes into the picture that he knew about after the trust has been handed out to the heirs? Is that just a done deal?
It sounds like a real fact pattern here. The answer is it depends on how the trust is drafted. So if he was aware of this other child and it was his intention not to leave that child anything, what he should have done is he should have mentioned that other child in the trust and specifically said that he's making no provision for that child. If he fails to do that, there is a state law in most states, including Arkansas, that says that child was omitted accidentally. They're called pretermitted heirs. You want to learn a legal word today, right? So so the thought is that if I forget about a child, it must have been accidental, and that child is entitled to whatever a child would have gotten. But you can solve that problem really easily by having language in the trust that says, I'm leaving everything I have to these people, and I have this other child out there, and for my personal reasons or no reason, I'm leaving that child out. That's not true in Louisiana, by the way, where there's a forced heirship. Louisiana is the only state in the country that doesn't let you fully disinherit children. But in Arkansas, you can. You don't have to leave your children anything. You can skip them and go to the grandkids, skip everybody, go to charity, or you can spend it all before you die. You have to time that right, though.
So you're saying if that trust says, I want Mary, Jane, Michael, and Sue to inherit, and then Bobby Joe comes in and says, oh, guess you didn't know about me, but that's my
Right.
dad.
Mm-hmm.
I want my share.
Right.
Then he can actually fight that?
Yes. Yeah. So that's why we, when we sit down with people, we do have to get kind of personal, and we have to say, tell me the names of your children, and are you sure that's all of them? And if you have some out there that we don't know about, tell me. So, you can certainly say, I want to leave everything to the persons, from this marriage. But if you know about somebody that's out there, and you don't mention them as intending to disinherit them, then there's a presumption that you just forgot about it. Okay? Yes?
What determines what's gonna go into probate? Is there a dollar amount, anything under this amount does not, but over that does?
So there is in Arkansas we have what's called a small estate probate, and it is a super simplified probate that says that if the total value of everything I have is less than $100,000 and all of my bills have been paid and 45 days has elapsed since I died, my family can go down and file a small estate, and it's basically one sheet of paper that says this is who gets everything. The probate clerk stamps it, and that's who gets everything. Okay? So there is a small estate. But that's just for the assets that are in your name. So remember a while ago I said if you have property that's in joint tenancy with other people and you die and those other people are still living, that doesn't go through probate. Okay? It goes to whoever's name is on the deed, right? If you have an IRA account or life insurance, that's going to pass by beneficiary designation to whoever you name. That's not going to go through probate. Okay, so what goes through probate is all the stuff you have that doesn't have a beneficiary designation, that's just in your name. And then if all of that is less than $100,000, you can do the super simplified version. And that doesn't take 6 months by statute. You can do that in 46 days, okay? All right. Mistake number 3, not protecting your surviving spouse. This is the issue that was a big deal for my wife. It's also an issue that you guys have raised a couple times. I have a picture here, by the way. This is your husband's next wife. This is a real common problem. This happens all the time, and almost every time. It's when a husband loses his wife that it's the issue. So the people that bring this up with me, probably 80% of the time, are wives. And it's not just a second marriage issue, because I think that every marriage is potentially a second marriage. Because if something happened to my wife, I mean, my wife believes that no husband can live on their own in the world, that they are completely helpless. And they have to have a wife, and there's probably some truth to that. And so when I'm doing work with a married couple, I always bring up this issue to find out if this is a concern or not. And it isn't always, but I will tell you that it is a real issue about half the time. And so when it is an issue, the solution is to create a testamentary trust inside your living trust for the benefit of your spouse. So do you remember a while ago we were talking about the chest of drawers, and I said everything goes in the top drawer. So what happens then is whenever that first spouse dies, we figure out what part of that trust belonged to him or her, the one that passed, and we put that in a drawer, in a separate drawer, and that drawer has a little bit of a combination lock on it. Okay. Typically, what I like to do is if we have a grown-up child that both parents trust, somebody that that they know that like in my case I would entrust my son with anything. And so in our plan I said if I die before my wife, my portion of what we have is going to go into a trust for her, and my wife is going to be a trustee of that, but my son is also going to be a co-trustee of that, so that if my wife gets swooned by some tennis pro out there, any decision made about the assets in that drawer will require my son to sign off on it. And I know my son, and he's not going to do stupid stuff with that. He's going to take care of his mother, make sure she's provided for, has everything that she needs. But if that marriage doesn't work, that guy has no claim on what's in there. And if that guy has this brilliant idea to open a fancy new restaurant and use her money to fund it, I just know my son's going to say no to that. He's not going to go along with that. And so, to me, that is the best solution for how to deal with it. Now, we don't always have family members that we can entrust with that responsibility, and so then we have to think about, do we have other family members, brothers, sisters, and if we don't have that, then do we go to a bank trust department, which, by the way, I think is a pretty good solution. But with this solution, we can make certain that portion of what's ours that I consider mine is going to be protected for my wife. Now, she's going to have control over her part. She can give that to the new guy if she chooses. I hope she doesn't, but she could. But the part that I'm leaving is going to be put in a lockbox with a combination, and somebody else is going to have the key. I'm trusting somebody that I know loves her, somebody I know will take care of her, but somebody that I know will say no under the right circumstances. A testamentary trust, and all of that is built into your revocable living trust if that is an issue. If it's not an issue, then we can just build a trust to say, whenever I die, everything goes into that middle drawer for my spouse, and there's no strings or restrictions on that. We do that sometimes too.
I have a question.
Yes.
Okay, so what if you don't have a spouse per se, but you share assets with a significant other, and because you share minor children?
Same deal. I do it exactly the same way. You don't, no, you don't have to be married, no. Okay, next mistake. I told you there were 5. This is number 4. What's my time? Am I good till noon? Is that the, okay, all right. I've occasionally been accused of talking too long, and I'm really trying to do better about that. This is one I really like talking about because there's so many opportunities here that people overlook. This is the mistake of not protecting your heirs from divorce, lawsuits, bankruptcy, and their own financial immaturity. I don't know, I'm not going to ask you, but I will tell you that in most families I work with, there's always one adult child that has not figured out how to manage money and how to live within their means yet, okay? This is absolutely true for minor children, but it's true for children in their 20s. It's true for children in their 30s. And it's true for children who are married to guys that like bass boats a lot. So my view is that if you're going to work real hard and save money and have something to leave as an inheritance, if that money is going to be wasted, you should be the one to waste it, not them. But most of us don't really want to waste what we work and save for. What we really want to do is we want to leave it so that that inheritance provides some financial security, an education fund, and improves the lifestyle of the people that we leave behind. And if we really want to make certain that's the case, then we need to make certain then that inheritance that we leave is protected in the event that heir gets divorced later. We want to make sure that it's protected if that heir goes out here and for whatever reason ends up getting sued by somebody and losing, and there's a judgment creditor who comes along and grabs it. If they file bankruptcy, for whatever reason, maybe they started a business that didn't work, it is possible, I want to show you, it is possible to structure your plan so that everything you leave to your heirs can be protected so that none of that can happen, okay? So how do we do that? How do we protect assets from the claims of future creditors? How do we protect heirs from their own financial immaturity? And by the way, let me tell you, Ohio State University did a study on this a few years ago, and they found that on average it takes about 19 months for heirs to get rid of an inheritance. Pretty scary thought, huh? The thing that most people do without thinking about it very much is they will create an estate plan, a will or a living trust, and in that will or trust they will say, when I die, just leave everything to my kids equally and outright. Divide it between them, give it to them. That's the way most people do it if you don't put the brakes on and have a thoughtful conversation about better options. One of the things we do in every single client meeting we have with our clients is we get every client to talk us through the family. I like to start with the oldest and hear the story. I like to hear what they're doing, who they're married to, how many kids they've got. I like to hear about, like all the kids. I like to have my clients give me their own assessment of their children's level of financial maturity, the dynamics of their marriage relationship, what kind of influence the spouse has on them, all of those things. because all that informs how we have the conversation about how to leave property to heirs. What I know is that if when I die, if I leave everything to my heirs outright and with no trust, that means that if they get sued, a creditor can grab that and take all of it. If they get divorced, their spouse is going to have a claim on it. But I will just tell you honestly, the biggest problem with divorce is that if I leave property when I die to heirs outright, it's a memorable day when your inheritance comes in. The day that that account is open for you, you probably go out to dinner with your spouse, right? You just had this money come in. So let's go out to dinner. And over dinner, you know what they're going to talk about? Whose name are we going to put this money in? And there is an enormous amount of pressure to take inherited money and put it into joint accounts. Most of the time, that's what really happens. And once you put it into a joint account, it becomes joint property. And then if they get divorced, the spouse has half of it, right? Now, there are also problems even if you don't put it in a joint account, but the put it in a joint account issue is a huge problem. So I like to head that off by creating a testamentary trust. Remember I told you we had this chest of drawers. I've got my top drawer, I've got the middle drawer for my wife, and I've got the bottom drawers for my sons. So what I want to do there is I want to say that whenever my wife and I are both gone, I want to leave the inheritance I'm leaving to my children, not outright, not just with their name on it, where it's completely available to be taken by anybody. I want to put it in a lockbox where it's protected from divorces, it's protected from their judgment creditors, protected from all those things. And the mental image I want you to form is basically this. I want you to think of those bottom drawers in that chest of drawers as a kind of a safe. If you could visualize that. I've got a chest of drawers, but there's a combination lock on it, and so somebody's going to have the combination. So let me speak to that. If I want to protect my son so that judgment creditors can't take his inheritance, he can't lose it in a bankruptcy, but I have total confidence in his ability to actually manage the money, I can make him the trustee of the trust. I can give him the combination. So what we're doing there is we're really protecting it from those outside predators. If I also was concerned that he was not financially mature enough to be a good steward of the money in that trust, I would not want to give him the combination to that. I would want to put that combination in somebody else's hands, at least for a while. I had a lady once, she said, my son is 60. I don't think he's ever going to get it. It's very common for us to set up trusts for people in their 20s and provide that they can become the sole trustee of their trust, but only after they've had a co-trustee serving with them for 3 or 4 or 5 years. Kind of like pilot training, right? You don't get to solo in the airplane the first day you get in it. You have to fly with an instructor for a while, and then, when the instructor thinks you're ready, they'll let you solo. I've got plans I've drafted where I said I'm going to name these family members as the co-trustees of this trust, and they can resign anytime they think this kid's ready for it. And if that kid's 50, they could still be keeping it. We want them to have the opportunity to see who they married, what influences that spouse has on them. How are they managing their own money? We get to observe all of this before we turn loose and hand them the keys to their own inheritance. We do all of that in what's called a testamentary trust. And in that testamentary trust, just like I said, you can protect a spouse, you can protect heirs from future divorces, future lawsuits, and bankruptcy. And if we're concerned about their lack of financial maturity, we can get somebody else to serve as a trustee or as a co-trustee and provide that kind of protection. And if you don't have a family member to do that, and about a third of the time, we just can't come up with anybody that really fits the bill there. We have to go outside and get a corporate trustee to do that. By the way, I've done this now for about 30 years, and boy, in 30 years you learn a lot about what not to do. And one of the things I've learned is that I almost never will let a client, I mean, ultimately clients do whatever they want, but if a client tells me I'm going to put a sibling in charge of another sibling's trust, I just make them sit there for a really long time. That is a really bad idea. Yeah.
Does that testimony always also protect from a government debt, a federal government debt as well?
Not taxes. It does. It is actually possible to draft a trust that can't be levied on by the IRS, but typically, the trust is still available to pay an income tax liability. You have to jump through a lot of hoops to get the IRS out of it, but I can protect it from an ex-wife. So most of the time that we spend in client meetings is really spent designing how these trusts work. They're really not one-size-fits-all arrangements. I mean, there are 1,000 different ways to do this, and how you do it really depends on you, depends on your family, what outcomes you're looking for. I have clients that say, I want to make certain that I'm going to put everything in trust for my son, and when he dies, it has to go to his children. I don't want him to have any say-so about where it goes. I have clients that say, I love my daughter-in-law, and if something happens to my son, I want it all to go to her. Now, I don't get that often, because they think she'll go get married again and leave it to this new guy, and we don't even know him, and we might not even like him. But I'm just saying that how you design this is a conversation we have to figure out what it is that that really reflects the outcomes you're looking for. Point is, it's not a one-size-fits-all solution. Anybody recognize this character? So he had a pretty major piece of Apple stock when he died. Do you know who got it? I don't know. What Forbes magazine said is that Steve Jobs did this right. He put it in a living trust. The only people that know who got it are the people he put in charge of the trust. He did it right. I want to make a point. I've been talking about revocable living trust here, and I want to make sure that you don't come away from this meeting today thinking that a living trust will protect your assets from long-term care. A revocable trust doesn't do that. Remember a while ago we were talking about why would you do an irrevocable trust? So I'm going to talk about that in a second, but I just want to make sure that you're all awake, you're all paying close attention, and that you've made a note to yourself or written down somewhere. A revocable living trust does not start the clock ticking on the 5-year Medicaid look-back rules. And I mention that because I think a lot of people have gone in to see somebody and had a living trust done thinking that it did do that. And it doesn't. I've had clients of mine who've come in years later and they said, oh, I don't have to worry about this nursing home thing, right? Because I did my trust years ago. I know. I never told them that. But somehow they got the idea that a living trust started the clock running. It doesn't. If protection from the cost of long-term care is an issue or concern for you, we have to look at other solutions. And I'm going to touch on that briefly. On Thursday, Todd's going to come and spend the entire session talking about how to do that. Just want to say the data is today is that, you all have heard that, we're all living longer, but not necessarily better. The data says that 70% of Americans will spend some time in a nursing home. Now, what does that mean? In Arkansas, at least around Little Rock, that's about a $6,000 a month ticket. Now, I had a client in Piggott, and I think they went in a nursing home and it was only about $3,500 a month, but Piggott's pretty far out in the country, right? And so I think you can go to rural areas, like way out in rural areas, and find $3,500, $4,000 a month tickets. But around Little Rock, any place that you'd want to be is going to be about $6,000 a month. The memory care units, if you catch Alzheimer's and need to go into a memory care unit, it's more like $7,000, $7,500 a month. So if you're a married couple and one of you has to go in a nursing home because the spouse can't care for you, we have to think about how much it costs to be in a nursing home, but we also have to think about how much it costs to keep the non-institutionalized spouse at home. If you're the spouse that doesn't need this kind of care, you still have to have a place to live, you still have to have food on the table, and you might want to take a trip or two from time to time. And so I don't know what your budget would be for that, but I would think that most Arkansans would like to think that they're going to have at least $2,000 or $3,000 a month, hopefully more, to maintain their lifestyle. So now we're looking at about a $9,000 or $10,000 a month cash flow drain because of the cost of care. A lot of people think Medicare pays for long-term care. It does not. Medicare will pay for, I forget, 90 or 100 days if you're hospitalized and you come out into rehab care. What's the number, Bill? Yeah, if you're hospitalized 3 days and come out, you can go into a nursing home, and Medicare will pay for care for a little while, but it's not a long-term solution. The state Medicaid program will pay for your care in a nursing home, but that is only true after you have spent everything you have down to less than $2,000. Now, there's some exceptions to that, but which I'm not going to get into. Todd's going to spend more time about that on Thursday. Yes, ma'am.
What about IRAs? Are they subject?
In Arkansas, IRAs have to be spent down. That is not true in certain other states. Oklahoma, for example, IRAs are exempt, but Kansas are exempt too. It's kind of weird, isn't it? It's like, why would you exempt an IRA? But yeah. But in Arkansas, everything counts. Your house doesn't count, but that's a bit of a misconception, because if you go in a nursing home and the Medicaid program spends money for your care and then you die, they have the right to do what's called a state recovery, which means they get to come back and sell your house and collect what they spent on you out of the sale of your house. So a house is not really protected. So when we do Medicaid planning, we always include the house as part of that, okay? The look-back period, there are two look-back periods. If you transfer assets away from yourself into the hands of other people, there's a 5-year look-back period on that. So when you go in a nursing home, the Medicaid people look to see what did you transfer in the last 5 years, and they use that as a starting point for defining your disqualification period. Let me just say also, and I think Todd's going to talk more about this on Thursday, but if you are a veteran, if you served in the armed forces and during a period of defined wartime, which are pretty broad, because we're actually still in a defined period of wartime for the Gulf War, because we've had, the Gulf War I and II and Afghanistan, Iraq, and all that going on. If you are a veteran and if you served at least one day during a defined period of wartime, I think you had to serve 90 days altogether. The rules change depending on whether you're World War II or Korea. They evolved a little bit. But basically, there was a rule change back in, it was October 18th last year. There was no look-back period. So you could go transfer all your assets away and then file for the benefit the next day and tell the VA you did it, and there was no issue. They changed that rule in October last year. So now there's a 3-year look-back period on the VA aid and attendance benefit. So I just want to be clear again that transfers to a revocable living trust will not qualify you for Medicaid or VA benefits. So what do you do? Let me first tell you what I think you should not do, and that is do not give property outright to children. And I've got some good reasons for that. This is very common that people do this, but I think they don't think about the consequences of that. Number one, children can die before you do. And then what happens? Where do they go? Now, people naturally believe I'm going to die before my kid's going to live long after me. That doesn't always happen. If you transfer your assets to them and they leave it to their spouse or somebody else, are you as confident that that spouse or whoever else is going to end up with those assets will use that money to take care of you as you are with your child? Your child can also get divorced and lose assets. Remember, if you transfer it, it's not yours anymore. It belongs to them, their name's on it, and then it gets caught up in the gears of a divorce. They can also get sued and lose it. They can have a bankruptcy and lose it. Or if they just don't pay child support and their ex-spouse gets a judgment, it can be lost that way. So what are the solutions? I want to offer 3 solutions for the nursing home for how do you pay for long-term care. Far and away, without any question, the best solution is to just be rich enough to pay it. And if you're rich enough to pay it, if we sit down and do the arithmetic and we find out that without having to work for a living, you have enough money coming in from investment accounts or rental property, Social Security, government retirement benefits, if we can add all of that up and it comes to enough to pay for it, that's the end of the conversation. We can go out to dinner and have a good time. About 80% of the people we talk to aren't rich enough to pay for it. You have to be pretty rich. I've done the math on this for a married couple. I think that if assets are reasonably well invested, I think you need about $2.5 or $3 million of investable assets to be able to just pay for it without having to think about it. So what about that other 80% that aren't rich enough? I've got 2 solutions, and I'm giving you my solutions in the order of which I believe you should consider them. There are today some really innovative insurance products. You all have heard of long-term care insurance. Long-term care insurance has gotten kind of a bad name in recent years because whenever the insurance companies sold it way back 10, 15, 20 years ago, they didn't know enough about the cost of long-term care to underwrite it correctly, actuarially. And so what happened is they started going bankrupt. They couldn't pay the claims, and they had to go into the state regulatory authorities, and they had to go do these blanket rate increases. So a lot of long-term care insurance has had rates double, triple. I've even heard of rates quadrupling. And that always comes much later when you have less money. So now you're getting bills 4 times what you thought they would be. So long-term care has gotten a bad name, and so almost no long-term care insurance is even being sold today for that reason. However, there are some really interesting, innovative life insurance and annuity products that are being sold today that I think really solve that problem. I think they're underwritten actuarially in a different way. But what's really cool about them is if it's a life insurance policy, there's a chance that you won't even need this coverage, right? I mean, you might just die and never go to a nursing home. So if you pay for long-term care insurance, it's like paying for fire insurance on your house, right? You only really come out ahead on that if your house burns down. So if you pay for long-term care insurance, you only get any of that money back. You only get a benefit of it if you actually go to a nursing home. But there are life insurance products now that you can buy that have a death benefit so that if you die and never went to a nursing home, your heirs get the death benefit. However, there's a rider on that policy that says, but if I do go to a nursing home, I can reach up and start grabbing that benefit, and that pulls down my death benefit, but at least I'm paying for it out of the policy. I'm not having to spend assets. I have pre-funded for that. You have to be sort of insurable to do that, but there are also annuity products. There's a whole combination of things. I'm not getting into the details of it, but I actually believe that this is a far more attractive solution than the next solution I'm going to show you. So when I sit down with people, it's a 3-part conversation. Part 1 is, are you rich enough that we don't have to have this conversation? Secondly, if you're not rich enough, can we get you qualified for some of the one or more of these insurance products that will just pay for it? And if the answer to all of that is no, then my third solution is to create an irrevocable trust. Remember a while ago we were talking revocable, and why would you do an irrevocable? Well, this is why you would do an irrevocable trust. If I take property that's belonging to me and transfer that to a Medicaid asset protection trust or to a veterans asset protection trust, if I do that properly, I can start that 5-year clock running on Medicaid transfers. I can start that 3-year clock running on VA transfers, so that after that period has elapsed, I will qualify for the benefit, and all of the assets that I've put in that irrevocable trust will not be counted as belonging to me, and so I can qualify. So the idea would be that to qualify for Medicaid, I would transfer all my assets away so that whenever I actually did go into a nursing home and they did a tally on my assets, I've got something less than $2,000 and I qualify on that day, okay? And so I may have transferred $300,000 or $400,000 or $500,000 out to my Medicaid Asset Protection Trust, but they don't count that because the 5-year clock is now run on that, okay? If I end up having to go into a nursing home before the 5-year period is elapsed, we just have to like suck it up and cut checks and pay for it until that 5-year period has elapsed. So, if this is a specific concern of yours, Todd, who knows more about this than I do, is going to spend more time than I spent today talking about that. But I did want to touch on that in case some of you weren't able to come to the Thursday session, because I know this is a really big issue for a whole lot of people. So let me just say quickly in closing, just ask yourself the question, you know, do you know you're protected? And if you're not, are you ready to do it? I want to say specifically there are three reasons why people don't take the next step to do planning. One is they don't know what to do. They're not clear on what to do. They're afraid of lawyer talk, and that is a legitimate fear, I promise you. And thirdly, they have no idea what it's going to cost. So I'm not going to give anybody a sales pitch today. I just want to say that when you work with us, I think that we're really good at helping you figure out what to do. I don't think it makes sense to wait until you figure out what to do to come see somebody to implement a plan. That's kind of like, you know, I'm not going to go to the doctor until I can write my own prescription. I think the value that we really bring is being able to sit down with you and really make you aware of the whole range of solutions that are available, that many of which you may not have even known existed. Secondly, we have a rule, at least in our office, we have a rule that we have to speak English to our clients. We do not permit our team to use lawyer words. How many lawyer words have I used today? One for sure, right? Yeah, okay. But y'all gave me permission to do that. And then thirdly, before you ever commit to move forward, we have a very frank discussion about what it costs to do things. I mean, and the fees vary widely depending on what it is that you're doing, but you will know about that in advance before you have any commitment to move forward. One thing I can tell you is that to find out, we don't charge for that. If you wanted to take the first step, you can have a discovery meeting. You would sit down with Bill. Bill does the first cut, and he can give you an idea after he knows your facts, generally how we approach this, what our fees would be, and then you can decide if you're ready to move forward. If you think this is something you want to do, Miss Amanda is sitting right up here, and you can tell her that you're interested. I can tell you this, that whenever we get a plan in place, we get hugged an awful lot. People come out and they say, Stan, I think I weigh about 30 pounds less than I did when I started this process. I definitely feel lighter. I think that when you know you're protected, when you know your family's protected, it definitely feels good. With that, let me say how much I appreciate the opportunity to be here. I'm not going to run off. I'm going to stick around and answer questions as long as you all want. But thank you all for being a very engaged audience. Yes?